Right, good afternoon everyone. Welcome to our professional webinar series today on property settlements and family companies. By way of brief introduction, my name is Leanne Murphy. I'm Special Counsel at Michael Lynch Family Lawyers. I've practiced in family law for over 15 years in Australia. I'm looking forward to speaking to all of you this afternoon in relation to this topic. If there are any issues during the presentation, you can either call the office or you can put in a chat. Also, if you have questions during the seminar, there's a facility on your screen to put questions in. If I can answer them throughout the seminar, I will do so. Otherwise, I'll deal with them towards the end. Right. By way of overview, these are the topics I'll be covering today. The 5-step process and why it's important, the identification and disclosure of corporate and trust assets, the family business, CGT and CGT rollover relief, loan accounts and stamp duty exemption. One of the first and most important processes undertaken in property settlement matters is to identify the composition and value of the assets of the parties to the relationship. This includes the value of corporate entities, the amount of corporate and personal liabilities, the identification of liabilities that may or will accrue as a result of property settlement transactions, such as capital gains tax and other realisation costs. These steps are key to understanding what the court process will be. So the 5-step process starts at step 1, which is it just and equitable to make a property adjustment order? So there will be particular circumstances where it will or won't be just and equitable for an order to be made in the first place. For example, where there is the existence of a prenuptial agreement, it may not be just and equitable to make a property adjustment order. Where the parties have conducted separate finances during the relationship, again, it may not be just and equitable to make a property adjustment order. And whether or not there are jointly held assets or singly joint assets will also inform us at this stage whether it is just and equitable for a property adjustment order to be made. In most cases, it will be appropriate to make a property adjustment order. And at that stage, we then move to step 2. Now, this is the identification of the asset pool. Now, the relevant date is the date of the agreement or a date of the trial. It's common to obtain updated valuations throughout the negotiation of property settlement matters, and therefore it's important for us to encourage clients to take steps to finalise property settlement matters as soon as possible after separation. Now, the next stage, step 3, is the assessment of the contributions. This is where we assess the financial, non-financial and parenting contributions of each party, taking into account the circumstances that existed at the commencement of the relationship, during the relationship, and in the post-separation period. Now, the longer it takes for parties to finalise property settlement matters, the more significant the post-separation contributions can become. Now, step 4. This is an assessment of relevant future needs and adjustment factors. Now, it's important for us to assess whether there are any relevant adjustment factors, including earning capacity, care of children under the age of 18, or any health issues that might impact upon a party's ability to generate income and assets in the future. Step 5 brings us back to an overall assessment as to whether it is just and equitable in the circumstances. Examples of relevant considerations may be whether it's appropriate for the equalisation of superannuation, or whether one or the other of the parties should maintain a greater amount of superannuation, and whether it's appropriate to preserve the home for the primary care of the party's child. The identification of assets, liabilities and superannuation sounds like a fairly easy task to undertake. However, for many unsophisticated clients, particularly for those who we can refer to as the non-financial spouse, is often the first of many financial-based tasks that they will have undertaken in their adult lives. It is surprising how many non-financial spouses are unaware of Things like the names of the trusts and corporations in the asset pool, the positions that they personally hold in those entities, whether or not a corporation, trust or business is income producing generally, and whether they specifically individually derive income from those entities, and if income is produced, the vehicle through which that income becomes part of their individual taxation income. So what do we do in this situation? Well, the first step is we often ask the company accountant. We do asset searches, we do title searches to identify property owned by the corporate entities. If that doesn't provide us with enough information, what do we do then? If your non-financial spouse client is a co-director of an entity, Sections 198F and 290 of the Corporations Act allows a director of a company a right of access to company books and financial records at all reasonable times in accordance in connection with legal proceedings. And if your non-financial spouse client has been a director within the last 7 years and may not still be a director, Section 290 of the Corporations Act allows the right to access those historical records. If neither one of those avenues are open to your client, we can consider whether pre-action procedures in the family law rules is appropriate. Now, those pre-action procedures require parties to genuinely attempt to resolve matters, engaging in dispute resolution and complying with the duties of disclosure that would otherwise exist if they'd already been in proceedings. The last option is to file an application. The disclosure rules that apply at the start of a matter are of a general nature, and then they can extend to the more specific. Sometimes we are lucky to have situations where the issue of disclosure is dealt with easily and with a large extent of compliance. However, for those cases where our clients are either wanting more information or alternatively, they want to give the other side less information, it's important that we know what the rules are in relation to disclosure so we can help them navigate those rules. Now, there is a general duty for each party of the dispute to provide to each other party all information that is relevant to an issue in the case. This is quite broad. The duty extends to information that is within that party's possession or control. So that means if you have the authority to request a document from, say, an accountant, a bank or the ATO, then that is a document that is within your possession and needs to be disclosed. There are some more specific rules, such as Rule 12.02 of the Family Law Rules, which require disclosure of some specific documents, such as the 3 most recent taxation returns and statements, the 3 most recent financial statements and returns for any corporation, trust and partnership, 12 months of business activity statements, documentation evidencing the value of superannuation, and unless the value is agreed, a market appraisal or opinion as to the value of any item in which a party has an interest. Rule 1304 requires parties to disclose all sources of earnings, interest, income, property and financial resources. This applies whether the property, financial resources or earnings are owned by or come to the party directly or go to some other person or beneficiary or are held in corporations, trust, companies and other structures. Parties are also required to disclose any disposal that may have been made in the year immediately before the separation or since the final separation that may affect, defeat or deplete a claim. There are rules in the Federal Circuit Court which are similarly worded, although not precisely the same. Both sets of rules require disclosure of both direct or indirect interests in entities. In circumstances where the party only has an indirect connection to the entity and they do not have possession or control of the documents, that is likely to be a scenario where it's an acceptable basis for non-disclosure. Further, if we're trying to enforce disclosure of an indirect interest, it's necessary for us to show that the documents are relevant to an issue between the parties. Now, simply because a party in its role as a director, shareholder, trustee or beneficiary may have certain rights attached to those roles, it doesn't mean that that right extends to using those documents for family law purposes. Although there is a right to access documents as a trustee and a director of a corporation, access to the documents must be for a trust or corporate purpose. A trustee stands in a fiduciary relationship with beneficiaries and must use knowledge gained in that role for proper purpose. Similarly, A director stands in a fiduciary relationship with its shareholders and must use knowledge gained in that role for a proper purpose. In the case of a beneficiary of a discretionary trust, the only right attached to that role is a right to due administration. Accordingly, the right to access documents of the trustees can only be used for determining whether there is due administration of the trust. In order to argue that it's appropriate to have disclosure in relation to trusts, including the potential inclusion of trust assets in the property settlement matter, it's necessary to determine whether the trust is simply the alter ego of the parties or is separate. Now we look at the indicia of control in relation to trusts. Now, these are questions that we have to ask either with the assistance of an accountant or not. Does one of the spouses have the sole power to appoint or remove a trustee or to change a beneficiary? Is the trustee, either a party or a company, completely controlled by one of the spouses? Is a spouse or company controlled by a spouse also the beneficiary of the trust? And does one of the spouses receive or can receive or is entitled to receive the majority of benefits in the trust? If the answer to one or more of those questions is yes, then we likely have a control scenario. We also need to look at a few other pieces of information. So as lawyers, we'll often revert to our clients' accountants to obtain all of the necessary information to help us determine the control definitively. So there's further indicia of control here listed for you. Who's the trustee? What are their powers? Who is the appointor? Who are the beneficiaries? Who's received distributions in the past and who hasn't received distributions in the past? Who's receiving distributions now? For example, in the post-separation period. Have there been restructures or amendments to the trustee? When did these occur? Did they occur in the post-separation period? When were the assets of the trust purchased? Are they historical? Are they recent? The best source of this information is the trust deed and any subsequent deed of amendment. And these are documents which we can obtain from accountants or our clients directly. We do a similar process for corporations. In order to determine whether the assets of a corporation should be included in the asset pool and be available for distribution upon property settlement, it's necessary to determine whether the company is the alter ego of the parties jointly or one of them. This is the information that we need to help determine whether that's the case. Who is the director? Who is the shareholder? Have there been any changes to those shareholdings over time? What are the rights that are attached to each class of shares? And we require more than just mere control. It's necessary to demonstrate power to take action and to prevent action from being taken in the corporation by a party to the marriage, and the companies having no existence and direction separate from that of the relevant shareholder, which is also a party to the marriage. In many cases, the trust documents fall into the category of documents which either need not be disclosed because they're not relevant, or they are not in the possession or under the control of the party to a proceeding. Despite this, it is common for trustees and directors to disclose the requested documents for the following reasons: to avoid the trust or corporation being joined to the proceeding, to avoid the trust being subpoenaed, and although the subpoena may be able to be set aside, the trustee or director may prefer to avoid the costs involved in doing so. And the disclosure of the documents may assist the parties to settle the matter on a final basis and move on. Now, what do we do if a party refuses to disclose company or trust documents? The options facing us include joining as a third party, either the director or the trustee, issuing subpoenas to directors or trustees, or issuing notices to produce to parties. A subpoena requires a third-party individual or organisation to provide evidence, and this can either be by providing oral evidence at a trial or by providing documents. The person or entity that the subpoena is directed to, or a party to the proceedings, may object to the subpoena on a few different bases, such as relevance or privilege. A notice to produce is directed towards a party to a proceeding that requires that the party produce documents at the next hearing of a matter. Now, the family business. Corporations are a popular way to run a family business for two principal reasons: the security of limited liability and the taxation benefits that flow to the controllers of the corporation, including but not limited to the more favourable tax rate. In matrimonial matters, the family business presents lawyers and accountants with various issues subject to how they're managed. Commonly, we are faced with the following scenarios, some of which you may be familiar with. A company controlled by one or both spouses, a company that is managed with rare or no formal meetings and brief or no minutes of those meetings. One of the parties does not participate in the day-to-day management of the company and often signs, sometimes without explanation, knowledge or interest, any document presented to them for signature as a director of the corporation. And shares held by members of the family have dividend rights, but not voting rights, impacting the issue of control. Accountants and lawyers often become involved in these scenarios when, upon separation, the non-active party seeks to become involved in the management of the business for a number of reasons, including that they want to keep an eye on what their spouses are doing with the family business. The controlling party seeks to lock out the non-active party. The controlling party may prevent the other spouse from having access to books, records, or other company documents. And the controlling party may make changes to the banking practices of the company, which may have the effect of preventing or restricting access by the other spouse. The controlling party may make alterations to the dividend policy of the company, or the controlling party may make a change to the operation of loan accounts. All or any of these scenarios will warrant some action. So what is the court's jurisdiction to deal with family businesses where action needs to take place? Now, the court can make in personam orders. So this is jurisdiction to deal with the company by orders directed to the parties in person, often in their capacity as a director or a trustee. There's also the court's jurisdiction to deal with the company under the Family Law Act with third-party provisions and injunction provisions. The court's jurisdiction to deal with the company under the Corporations Act 2001, and the court's exercise of accrued jurisdiction. Where the company is owned wholly by the parties to a relevant relationship, being either a marriage or a de facto relationship, the reach of the Family Law Act is usually sufficient. In this regard, the court's powers to make in personam orders in most cases does not require the exercise of the Corporations Act. In this respect, the court has wide powers to grant injunctions pursuant to Section 114 of the Family Law Act. In this case, the use of injunctions either by the controlling party to keep the other spouse out of the business, or by the spouse against the controlling party to require ongoing disclosure, communication and verification of business practices. Some corporations will necessarily involve other third parties, and there are third-party provisions in the Family Law Act that allow the court to make orders in relation to third-party matters. Alternatively, the corporations law can also be used to assist in third-party matters. Sometimes, as family lawyers, we will seek to invoke or apply the relevant sections of the Corporations Act simultaneously with the Family Law Act. There are many sections that we might use as family lawyers. However, the main ones include the basic statutory obligations of directors, their provisions in relation to access to company books, the provisions in relation to inspection of company books, and the duties and liabilities of officers of corporations. The first expert that is often approached in a property settlement matter is generally the family or company accountant. If the property settlement matter is a simple house and garden dispute, the family accountant is approached to assist the parties to complete personal tax returns, collate documents required to be disclosed as part of the property settlement process. However, if the property settlement involves a family business structure involving the parties to a relationship and no other third parties, the accountant is approached to identify if the business has a value, and if so, to assist the parties or one of the parties to brief a joint expert valuer as part of the property settlement process. If the property settlement process involves complex corporate and trust structures, the accountant will be approached to identify what, if any, documents can be disclosed automatically based upon the roles and interests of the parties to a marriage and the roles and interests of relevant third parties, including any objection by the third parties to the production of documents, and also to assist the joint expert valuer as part of the property settlement process to provide documents and information. As part of the property settlement process, there is significant specific advice required that enables us to prepare documentation. What, if any, resignations are required to affect the transactions? What transfers of shareholdings are required? And are there any planning issues associated with the transfer of particular classes of shares? Capital gains tax identification and calculation, the identification and treatment of loan accounts upon settlement. It might also be necessary to consider whether specialised advice is obtained in relation to workplace matters, such as the exiting conditions of one spouse from a position as employee of the family business. Capital gains tax is a key area of consideration when preparing property settlement documents. Rosati outlines the general statement relating to whether the disposal cost of an asset, including capital gains tax, is to be taken into account and deducted from the pool. These questions often arise in some specific circumstances, and that is when someone is retaining an asset that is pregnant with CGT. That can be retaining a bundle of shares or retaining investment properties, for example. So the full court in Rosati identified the following general principles that apply, and there are 4 of them. Whether the incidence of CGT should be taken into account in valuing a particular asset varies according to the circumstances of the case, including the method of valuation applied to the particular asset, the likelihood or otherwise of that asset being realised in the foreseeable future, the circumstances of its acquisition, and the evidence of the parties as to their intentions in relation to that asset, being whether they intend to dispose of it or not. The second principle, if the court orders the sale of an asset or it is satisfied on the evidence that the sale is inevitable or would probably occur in the near future, or if the asset is one which was acquired solely as an investment and with a view to its ultimate sale for profit, then generally allowance should be made for any CGT payable upon the sale in determining the value of that asset for the purposes of these proceedings. Third principle in Rosati, if none of the circumstances in the prior applies to a particular asset, but the court is otherwise satisfied that there is a significant risk that the asset will have to be sold in the short to mid-term, then the court, whilst not making specific allowances for CGT payable on such a sale in determining the value of the asset, may take it into account as a relevant Section 75(2) factor. So that's a future adjustment factor. The weight to be attributed to that factor, varying according to the degree of the risk and the length of the period within which the sale is anticipated to occur. And the fourth principle, there may be special circumstances in a particular case which, despite the absence of any certainty or even likelihood of a sale of an asset in the foreseeable future, it's appropriate to take the incidence of CGT into account in valuing that asset. In such a case, it may be appropriate to take CGT into account at either its full rate or at some discounted rate, having regard to the degree of risk of the sale occurring or the length of time which is likely to elapse before that occurs. And we will often talk to accountants in relation to the relevant CGT calculations. However, I've put up the CGT checklist for you. So we need to determine which assets will be dealt with as part of the property settlement and which are subject to a disposal or readjustment in the transactions in the property settlement. It's necessary to determine the acquisition date of each of the individual assets that are subject to the property settlement transactions, establish the identity of the current owner of each of those assets, and establish what the date of disposal will be. And that will generally be the date of an order, or sometimes it could be a specified time period such as 60 days from the date of this order, for example. And there are separate rules that apply to the pre-CGT assets and post-CGT assets. Again, generally, where evidence is being provided to the court, we will ask an accountant to prepare those calculations. CGT rollover relief only applies where there is a court order or a financial agreement if the parties are separated and the CGT event happens in direct connection with the breakdown of the relationship. Management of CGT and CGT rollover relief is often one of the more important revenue considerations in a division of property upon a marriage or relationship breakdown. The relief is potentially available not only where there is an asset disposed of between spouses or former spouses, but also where an asset is disposed of by a company or a trust to a spouse or a former spouse as part of property settlement transactions. The effect of the rollover will be where the asset is a pre-CGT asset, the status of the asset is maintained in the hands of the transferee, so that if and when the transferee disposes of it, there will be no capital gains tax liability. And if it is a post-19 September 1985 asset, any incidence of CGT is effectively deferred and assumed by the transferee. The identification of a CGT event in the transactions proposed to be part of the property settlement matters is absolutely necessary. This could impact whether or not the parties decide to retain or dispose of properties as part of that process. And if it's disposed of, then they can crystallise and share the CGT liabilities between them there and then. While the court has a discretion as to how to treat liabilities generally, the court will take into account liabilities of the parties to a relationship as it finds them and will not ignore the assets and liabilities in the loan accounts of family businesses. In some circumstances, it is appropriate to include the value of a current debt owed to a third party. However, it is necessary to assess those debts and to ensure that the value has been calculated appropriately. Further, it is generally appropriate to disregard transactions between parties to a marriage and the family business in circumstances where the entity is, in essence, the alter ego of one of the parties. In the case of Fodder, the husband alleged that a debit loan account in his name had been debited with monies advanced to the parties to the marriage to purchase real properties which were, at that time, held in the name of the parties. The trial judge attempted to account for the sum as an asset of the business and liability of the parties. However, the value of the loan account was unclear at the time. On appeal, the full court determined that transactions between the parties and the company should have been disregarded and that there is no need for accounting between them. In this case, however, the net effect was that the debt by the husband was not recorded as an asset of the business for liquidation purposes, which is likely to have been impacted or to have changed the overall value of the pool once liquidators were appointed. It's always important to obtain advice in relation to the treatment of loan accounts. In most cases where loan accounts exist in corporate and trust entities that are controlled by parties to a marriage, ordinary methodologies will take the loan accounts into account properly, and the position will likely be one of neutrality. However, it is always necessary for us to see the financial statements and deal with the specific loan accounts that exist on the books at the time of the property settlement orders or the agreement, so that the loan accounts can be dealt with appropriately to ensure that the parties have severed all financial ties to each other. In the case of stamp duty, one of the primary pieces of advice that can be provided to clients is that an exemption of stamp duty upon transactions only arise when property settlements are formalised properly. So we should always discourage people informally dealing with property settlements. In Queensland, it's necessary to consider the Family Law Act, but also the State-Based Duties Act in relation to the treatment of stamp duty. There needs to be a valid order or a valid binding financial agreement. It needs to predate the transaction, it needs to specify the property being transferred, and it needs to clearly state who the property is being transferred to. Generally, particularly under the Duties Act, it provides that the transaction has to be between parties to a marriage. However, there have been exceptions. Recently, in a case that I was involved in, we had assets owned by an entity where the director and shareholders were the husband and the husband's adult child. It was necessary for us to carve out a real property from that entity and transfer it to a new entity of the adult husband in order for the court to simply deal with the assets of the relationship. It took 2 appeals to the Office of State Revenue, but we managed to save approximately $150,000 in stamp duty. In that respect, it's worth getting some good advice in relation to stamp duty transactions. Now, Division 7A loans often appear in family businesses. A deemed dividend arises when a private company pays an amount to a shareholder or an associate of a shareholder. And the term associate is quite broad, and if the shareholder is a natural person, the associate will also include the spouse. The payment includes transfer of a property, not just funds. The amount of the payment where property is transferred is the amount that would have been paid at arm's length, less any actual consideration by the transferee. So if the property is transferred at market value, no deemed dividend arises. If a payment to a spouse is made from the business pursuant to an order, this is a payment for Division 7A purposes and therefore a deemed dividend. It is vital, therefore, that any decisions by clients regarding the use of company funds in this way is done with the benefit of advice, and when there is no other way of satisfying a property settlement order, this may be an appropriate case to take into account the cost of transactions as a liability of the marriage. Looking at the case of debt forgiveness, a deemed dividend arises where a debt owed to the company by a shareholder or associate to the shareholder is forgiven. Again, a decision to use the debt forgiveness provisions in the context of property settlement orders should only be done upon accounting advice. Now, it seems that I have reached the end of my seminar today, and it must have spoken a little bit quicker than anticipated. I've noticed that no one has asked any questions, but feel free to put the questions in the website that you've got there, or alternatively, you can email those questions to law@mlynch.com.au. We've got many past webinars available on our website, and we do have more professional webinar series presentations coming in the future. One thing that I thought I'd cover right before we finish is that if you're an accountant or another specialised professional and you have clients who are looking to obtain preliminary family law advice, Michael Lynch Family Lawyers offer initial consultations. We have two particular rates, $440 including GST to visit with one of our accredited specialists, or $385 including GST with one of our special counsel or associates. This is designed to provide a broad brush range of advice in relation to property, parenting, and child support matters, and to give your clients some advice which help them to decide how they want to proceed. So it looks like no other questions have arisen at this particular point in time. I want to thank you for being present at this webinar. Thank you very much.